For years, we've watched the same story. Activist judges tying the hands of elected officials, blocking common sense immigration enforcement, and letting the system grind to a halt while American communities bear the costs. That changed this week. In a major victory for the Trump administration and the rule of law, the full Fifth Circuit stepped in en banc, vacating a panel decision that would have forced bond hearings and potentially released detainees. This backs the government's ability to enforce mandatory detention, and for those subject to removal, especially individuals who entered without inspection. In other words, illegal aliens. Today, you're going to learn exactly what happened in this case and why it represents a huge win for deterrence and enforcement, the constitutional principles that are at stake, and where this heads next, almost certainly to the Supreme Court. So stick with us. My name is Kelly Jackson. This is Still Not Canceled, where we question everything, especially the narrative, and we don't just tell you what happened, we explain what it means. I'm going to start with this clip from Mike Davis, who is talking to Steve Bannon a little bit about the ruling.
Well, there's a couple big decisions, one out of the Fifth Circuit Court of Appeals and one out of the Second Circuit Court of Appeals. In the Fifth Circuit, you have these illegal aliens or these non-citizens who have been in America for a long time. And Trump's Department of Homeland Security, Trump's ICE, is picking up these guys and detaining them as they should. And then you have these left-wing judges jumping in and throwing on their capes instead of robes, thinking they're superheroes instead of following the law. One of these narcissistic superheroes who thinks he wears a cape instead of a robe is this Judge Robert Pittman down in Austin, Texas. He's this left-wing radical Obama judge, and he held that these long-term non-residents get individualized hearings under the Fifth Amendment to the Constitution, meaning ICE can't detain them, or it's going to be very difficult for ICE to detain them. A three-judge panel on the Fifth Circuit affirmed that. A Bush 43-week judge, an Obama judge, and then a Trump judge dissented, of course, because Trump's judges are generally rock solid. And the full Fifth Circuit, it's called en banc, meaning the full Fifth Circuit just stayed that Fifth Circuit panel ruling and that left-wing judge in Austin and said, no, you got that you can detain these immigrants. So that's key. That's going to be a key deterrent. If you are a non-citizen, if you should not be in this country, you should understand now the Trump Justice Department, Trump DHS, Trump ICE can hunt you down legally and throw you in detention, and you're going to sit in detention for a very long time while you try to adjudicate your BS claims. The alternative is to get the hell out of our country, and DHS makes it easy for you to do that. I think you can even get money to get the hell out of our country, but you need to get the hell out of our country. So that's number one.
Mike nails it. This isn't just a procedural move. It's a practical game changer for immigration enforcement. The practical effect, by vacating the panel's ruling requiring bond hearings within roughly 90 days, where the government would have to justify continued detention. The full Fifth Circuit has restored the status quo of mandatory detention under the administration's interpretation of 8 U.S.C. 1225, subsection B, subsection 2, subsection A. District court orders granting habeas relief or release are stayed or impacted, allowing ICE to maintain custody during removal proceedings for those treated as applicants for admission. On deterrence, clear, consistent enforcement signals that illegal entry or unlawful presence won't lead to quick release into the interior. It discourages frivolous claims and exploitation of the system, reducing the incentive for more crossings or overstays. When detention is reliable and prolonged where needed, it breaks the cycle of catch and release that has plagued prior policies. This could encourage voluntary departures. Many individuals facing removal, especially those without strong claims, may choose to leave voluntarily rather than linger in prolonged detention. It ties directly into incentives. Strong borders and interior enforcement create a framework where legal pathways are rewarded and violations carry real consequences. Congress set up this detention authority. Courts shouldn't rewrite it on the fly. Let's break it down clearly. District judges had been granting habeas relief to petitioners, longtime residents detained after traffic stops or similar, with no criminal records in the examples, ordering bond hearings or release. They ruled that even under mandatory detention statutes, due process required individualized review after a certain period. A Fifth Circuit panel decided around July 2nd of 2026 affirmed aspects of this, holding that while statutory mandatory detention applies, the Constitution's due process clause kicks in for prolonged detention. It required the government to provide bond hearings within 90 days where it bears the burden to show flight risk, danger, etc. The full Fifth Circuit then granted en banc hearing, vacated the panel opinion, and issued stays of the district court orders. This was signed by a majority of judges, keeping detainees in custody pending full review. The arguments for that are likely in September. Why the full Fifth Circuit matters. En banc review by all active judges allows the court to reconsider and potentially unify or correct panel decisions, especially on high-stakes issues with broad impact. This signals the panel may have gone too far on the constitutional side, giving the administration some breathing room. There's a core distinction here. The Fifth Amendment's Due Process Clause protects persons within U.S. jurisdiction, not just citizens. Non-citizens, even those unlawfully present, get some protections. But immigration detention isn't ordinary criminal punishment, it's civil, and it's tied to removal. Congress created the framework. Statutes like 1225B mandate detention for certain inadmissible aliens, applicants for admission, including many who entered without inspection under the government's view. This reflects legislative intent for firm control over who enters and stays. Prior administrations interpreted it more narrowly, but the text and history support a broader application. Challengers argue that prolonged mandatory detention without any individualized hearing violates substantive and procedural due process, especially for longtime residents with family ties, U.S. citizen children, and the like. They cite Supreme Court precedents which limits removal detention and upholds mandatory detention, but noting its typical brevity. After 90 days or so, they say the government must justify a continued hold. The DOJ and the government argue that Congress made the categorical choice for mandatory detention in these categories. Courts shouldn't second guess that with case-by-case hearings that could overwhelm the system. Aliens at the border or deemed seeking admission have fewer rights. Plenary power over immigration gives the political branches wide latitude. Due process is satisfied by the removal proceedings themselves. As far as separation of powers is concerned, this is huge. Immigration policy is fundamentally an Article 1 and 2 matter. Congress sets the rules. The executive branch enforces it, and judges overriding that via a constitutional gloss risk turning courts into super legislatures, especially while core questions like statutory scope and plenary power remain live. It matters beyond immigration. Precedent here could affect national security detentions, wartime measures, or other areas where Congress delegates broad executive authority. If judges can impose bond hearings anywhere, it erodes the framework Congress designed. Where does this go? The victory is real, but it's interim. The en banc process means that the panel ruling is vacated. No immediate nationwide or circuit-wide mandate for bond hearings. Detentions can continue under the mandatory framework while the full court weighs the constitutional claims. Questions remain unanswered with regard to exact limits on prolonged detention, precise burden shifting in hearings, if there is any, and how far due process extends for applicants for admission with deep U.S. ties. Circuit splits and other circuits have gone different ways on statutory or constitutional issues, make Supreme Court review highly likely, possibly this term or next. The administration can keep pushing enforcement priorities in the meantime. Today's ruling wasn't just about immigration. It was about whether judges or elected branches of government set immigration policy while Constitution questions are still being answered. That's why this week, this ruling matters. And it's why this case is almost certainly headed to the Supreme Court. Thank you so much for joining me today at Still Not Canceled, where we question everything, especially the narrative. And anyone can tell you what happened, but we explain why it matters. My name is Kelly Jackson. If you haven't already, like, subscribe, give me your comments in the comments section. I will address every single one of them, or even make a suggestion on an issue that you might want to hear me do a deep dive on for the next video. Thanks so much, and I appreciate you tuning in. See you next time. Bye-bye.